Today we are going to be discussing mutual assent, which is an agreement between parties. This agreement or meeting of the minds is referring to the offer and acceptance section of a contract. But for this lesson, our main focus will be on acceptance and U.C.C. 2207. Under Article 2 of the U.C.C. there are two sections that deal with offer and acceptance. They are sections 206 and 207. 206 deals with offers and acceptance and 207 deals with an acceptance that has additional terms. You may have heard this referred to as the battle of the forms. Finally, we will also look at the knockout rule, which is also associated with section 207. Let's start with offers and acceptance and section 206. The U.C.C. wants to find a contract, so they are very liberal when it comes to what constitutes an offer and acceptance. The basic premise is that an offer may exist when an opportunity for an acceptance has been created. An offer under the U.C.C. requires three things to be valid. These are: 1. An expression or willingness to enter into a contract; 2. Certain and definite terms; and 3. Which are communicated to the offeree. The language regarding an offer is shown here. An offer to make a contract shall be construed as inviting acceptance, in any manner and by any medium reasonable in the circumstances. I think we can all agree that's a pretty broad description. Section 206 goes on to say when the offer or order requires a promise to ship or prompt shipment of the goods, the acceptance can be given by a return promise to ship or a prompt shipment. So in this scenario, a seller receives an order, and then plans on accepting the order by sending the goods. If the goods that are sent are non-conforming, then it is a breach. The buyer may keep the goods and sue for damages or reject the items. In the next scenario, if the seller ships non-conforming goods but includes a note of accommodation, then it is a counter-offer which the buyer may accept or reject. The seller may have a chance to cure the non-conforming goods if the buyer agrees. In a situation when an acceptance is received that is in written format, which includes emails, faxes or letters, there may be additional terms that were not part of the original agreement that was discussed. In this case, we look to section 207 to determine how to proceed. There are three elements under 207. The first section is used to determine if the additional terms constitute an acceptance or a counteroffer. The second section determines if the additional words will be added to the contract. The third section will determine if the acts of the parties constitute a contract. Let's break down each element. In element number 1, there are 4 tests to see if the writing is an acceptance or a counteroffer. They are: 1. A definite and seasonable acceptance. 2. That is sent within a reasonable time. 3. Is an acceptance even though additional or different terms are present. And 4. Unless acceptance is made conditional to the assent of the new terms. The entire section hinges on number 4, so let's take a closer look. Number 4 is saying that the additional terms must be accepted to be considered an acceptance. However, these conditional words cause the acceptance to actually become a counteroffer. So if any of the elements are false, then it is a counteroffer. For this example, we will agree all 4 sections are true. In this case we go to section 2. Once we determine the elements do create an acceptance, then we go to section 2 and see if the additional terms will be included. This will depend on the status of the parties. If any of the parties are not merchants, all of the additional terms must be agreed to by that party. However, if both parties are merchants, the additional terms are included unless the offer expressly limits acceptance to the terms of the offer, the offerer has already rejected them or rejects them within a reasonable time, or they materially alter the contract. Finally, in section 3, a contract can be formed based on the conduct of the parties with mutually agreed upon terms, used along with gap fillers as needed. So let's do a quick review before we try an example. 206 states that an offer can be made in virtually any way that creates the power of acceptance in another. Acceptance can be given via promise to ship or prompt shipment, as we are dealing with goods in the U.C.C. 207 deals with situations where there are additional or different terms in an acceptance. There are 3 sections, each having their own elements that must be met. For section 2 to apply, both parties must be merchants. So here is an excerpt from a contracts exam that was given in 2020. The U.C.C. will be the governing law because they are talking about buying and selling guitars, and guitars are movable and tangible, which make them goods. Additionally, we were previously told at the beginning of the exam, which doesn't show here, that both parties are merchants. We are going to try what we learned today, see if we can find an offer, an acceptance, and see if there are any different or additional terms. As we go through this exam, we are going top to bottom as contract's answer is always given in a linear fashion. In green, you can see where we find an offer. Buyer emailed seller asking for goods to be delivered, which is an offer to purchase. The parties, subject matter and quantity are all present, so the offer would be valid since the terms are definite and complete. Next, we see in blue that the seller accepted by promising to ship. The 14 days can also be argued as an additional term under 207. Next, in orange, we see that there are additional terms from the seller, so we need to follow section 207. However, we are told that there are additional terms that were not previously discussed that are added. We don't know if the catalog had any terms listed, so we can argue that both the 14-day delivery timeframe and the complaints or return sections are all additional terms. Finally, just to see how the knockout rule is used, we will say that the catalog listed payment as due 10 days from delivery. The knockout rule, which addresses different terms than were in the offer, will be knocked out and gap fillers will be used. Additionally, courts may look to course of performance, course of dealing, or trade usage to help manage these terms. So there you have it, offer and acceptance under the U.C.C. We hope you enjoyed our overview and that this helps you with your studying.